They were back to the sound of yellow X. Hello.
Right, this is 26 CF 1717, State of Wisconsin versus Catherine Moffett. Appearances, please.
ADA Carl Lassers for the state.
Attorney Adam Welch appears with Ms. Moffett. She appears in person and in custody. We've received a copy of the complaint. We will waive its reading. The address listed on the complaint is accurate, and she does qualify for a public defender.
And I've reviewed the complaint. It contains probable cause. What's the state's position on bail or bond?
Yes, Your Honor. In Ms. Moffitt's case, the state is asking for a signature bond with conditions of no controlled substances or drug paraphernalia without a valid prescription.
Any objection?
No.
All right, order a signature bond with that, those two conditions. Time limits for preliminary hearing, counsel.
We'll waive them.
I'll find that Ms. Moffett has waived the time limits for the preliminary hearing. We'll schedule the matter for a status.
Next is Brook Fuel. Good work. You stand on the yellow X.
There are three cases here, 26 CF 1026, 26 CM 654, and 26 CM 1848. All of which are State of Wisconsin versus Brook Fuel. Appearances, please.
ADA Carl Lassers for the state.
Attorney Adam Welch appears with Ms. Buell. She appears in person and in custody. We've received a copy of the new complaint. I just need one moment, please.
Is that the right zip code or is it just 93? Is it 1-3?
It's right.
It's right like that. Okay.
There should be the PO box just from the post office PO box number 2 with the name and friend but I use my mom's. I can't use that address.
So can you use the PO box?
Yeah, PO box number 2 Brenda Osborne.
Brenda Osborne.
They said they just put it in her box.
And that's still the same arena zip code. Okay.
We do have a update to the address. And this I'd ask to be consistent across all the cases if that's not too much work. PO box number 2, care of Brenda Osborne, Arena, Wisconsin 53503. And then Ms. Buell does qualify for the public defender.
Okay, with respect to the 1848 case, I have reviewed a copy of this complaint. It contains probable cause. What's the state's position on bail or bond?
Yes, Your Honor. I believe both the bond hearings are at least in part related to a failure to appear from Friday. Is that Your Honor's understanding?
Yes.
In each of those cases, the state would ask that the previous signature bonds with the same non-monetary conditions be reinstated. And in the new case, 1848, the state would also ask for a signature bond with conditions of no controlled substances or drug paraphernalia without a valid prescription and a ban from all target locations.
Any objection?
No.
All right. I'll reinstate the signature bond on the other two cases and order a signature bond in the 1848 case as well. The conditions will remain the same on the older two cases with respect to the 1848 case. While this case is pending, ma'am, I'm going to order that you not possess any controlled substances or drug paraphernalia without a valid prescription.
So that pay bond for the other one, so take it out.
No, they're reinstating your previous.
Sounds good.
Actually, you need to make sure you check for your next court date.
Yeah.
Sure that, okay?
I didn't say it, but with respect to this 1848 case, you'll be banned from any target location while the case is pending. I heard you say you forgot your court date. Make sure you come to the next one. It's okay. I just want you to make sure you remember the next ones.
You don't need to right now.
Ah.
Just go with them and get out of here, okay?
So I'm gonna go home.
Yes, ma'am.
I don't have to pay nothing about those.
This way. Next is Cora Marie Brown.
What did he say?
Brown, Cora Marie.
Cora Marie Brown for
Forfeiture. That's why I don't know who that is.
Ms. Brown. This one. You go stand up and have it.
Good afternoon. Good afternoon. Are you Cora Marie Brown?
Yes,
Ms. Brown, I have in front of me a forfeiture complaint. I imagine you have it in front of you as
Yes.
well. It charges you with one count of county obstructing or resisting an officer.
okay,
It's a non-criminal charge. It carries no potential jail sentence.
okay,
The maximum penalty is a forfeiture of money only.
okay,
So I'm going to ask you how you wish to plead to this, but before you answer my question, I want you to know a couple of things.
okay,
First, no matter what your answer to this question is,
Okay.
this is not going to continue to hold you in jail any
Okay.
longer. The second is that sometimes in these kinds of hearings, the county wishes to make an offer to resolve the matter today.
Okay.
Would you like to hear any offer, Attorney Lazarus?
Yes, Your Honor. We would offer to resolve this case for a plea of no contest for court costs only.
So, Ms. Brown, what that means is that if you wish to enter a no contest plea to count one,
okay,
the county will recommend and I will order that you pay court costs, $114.50. I can give you a couple of months in which to pay that.
Yeah.
How would you like to plead to the obstructing or resisting an officer?
no contest.
All right, I'll find you guilty based upon your no contest plea. I'll order that you pay court costs of $114.50. I'll give you 60 days in which to pay that.
Okay.
All right, we're
Okay,
adjourned.
this way. Next is Samuel Holt, appearing via Zoom.
All right, this is 26 CM 1847, State of Wisconsin versus Samuel Holt. Appearances, please.
ADA Carl Lazarus for the state.
Your
Attorney
Honor,
Adam.
Mr. Holt does not want to participate.
All right, I can see that there's a door with a
Okay.
spot open. It appears dark inside.
All right, Attorney Adam Welch from the Public Defender's Office appears on behalf of Mr. Holt. There is a Zoom video feed set up from, I believe, the city county building jail. We've been advised by a bailiff that Mr. Holt is within the cell, but refusing to come to the food slot to participate in the hearing.
So today is the must go day for Mr. Holt under our local court rules. This is the only thing that is put in custody.
Okay. So we'll proceed with the initial appearance, even without Mr. Holt's active participation. Although I'm guessing he can participate from where he is if he chooses to. I well, counsel, do you have any information about the address?
No, Your Honor.
Okay. I've reviewed this criminal complaint. It contains probable cause. What's the state's position on bail or bond?
Yes, the state would ask for a $500 cash bond and a non-monetary condition of a ban from State Street per the State Street ban map. The reason for that request is I believe this is the third pending case. There was a missed court appearance in the two pending cases, which I believe occurred on June 12th of this year, but then there was a return on warrant 3 days later, or what my notes reflect. No further argument.
We can just hold on for a moment. We had at least the option for the defendant to be listening and be available, but his door was just shut. Okay, we've got to go back up now.
All right, on behalf of Mr. Holt?
Oh, okay. So I actually was looking at the CCAP notes for this incident that happened in June. And the CCAP notes from June 12th through June 17th reflect that there was a off the record hearing where they did not see Mr. Holt, and then they authorized a bench warrant, but then there's a note on the 17th stating that the warrant was withdrawn and the defendant was in custody in the Dane County Jail at the time that the warrant was issued, which I think means that it was not Mr. Holt's fault that he didn't appear, that he was in custody and the sheriff's department just didn't produce him for the hearing. So I think that warrant was simply issued in error, and I don't think there was a failure to appear. I would then note that this is a disorderly conduct and bail jumping charges, misdemeanors that are not Act 3 eligible offenses. And I don't think a cash bail is necessary to assure Mr. Holt's appearance in court.
All right, thank you. Attorney Lazarus, is there anything you want to add, given those additional statements about the apparently missed appearance?
I'm not aware of any other information. I just know the return was only 3 days later, so it certainly could have been as described by Attorney Welch, issued in error. I don't have information to the contrary.
Commissioner, I did just look up the inmate housing record, Mr. Holt. It looks like he was in custody in the Dane County Jail at that time.
All right, thank you. Without the missed court appearance, I agree that a signature bond is the appropriate bond here. That's what I'll order. I will order that Mr. Holt be banned from the area depicted on the State Street ban map while this case is pending. All right, we're done on that case.
Next is Juan Perez. On the earth.
This is 26 CF 1725, State of Wisconsin versus Juan Perez. Appearance.
ADA Carl Lazarus for the state.
That's something that we find inside of us. Just so that it's where are you looking at? Here, from this side to where is the next not the level that has to be here. But also then the one that
Your Honor, we have received a copy of the complaint. We waive its reading. Mr. Perez does understand what he's being charged with. The address on the complaint is accurate. Mr. Perez has not been evaluated for a public defender yet, but he has been provided with the information sheet about that.
Mr. Dorotero Perez, you've been charged with a crime, so you have the right to be represented by an attorney. It sounds like you have information about applying for an attorney through the public defender's office. You should do that as soon as possible. If you don't qualify for an attorney through the public defender's office and you wish to be represented by an attorney, your options are to hire an attorney to represent you or ask the court to appoint an attorney to represent you. Right, I've reviewed this complaint, it contains probable cause. What's the state's position on bail or bond?
The state would ask for a signature bond and a condition of no controlled substances or drug paraphernalia without a valid prescription.
Any objection?
No.
Right, I'll order a signature bond. Mr. Dorotero Perez, while this case is pending, you are not to possess or consume any controlled substances without a valid prescription. You're not to possess any drug paraphernalia. Time limits for the preliminary hearing, counsel?
We'll waive the time limits.
I will find the defendants waive the time limits for preliminary hearing and schedule the matter for a status. Sir, you will get the next court date on your way out. Make sure you come back to court on that day.
Okay, yes, I will.
We're adjourned. Thank you.
Next is Cristobal Urquiza Durant. Thank you.
Peter Durant. That actually talk about. Oh, that's good.
This is 26 CM 1862, State of Wisconsin versus Cristobal Urquiza Duran. Appearances, please.
ADA Carl Lazarus for the state.
I live under the bridge. I don't know if you can tell me where the scene. I can. Absolutely. Here, do you see what title is that is happening? You know, write down. Sorry, that's yours. There's. Usted puede seguir su beacon. Yeah, okay. ¿Está de acuerdo?
Attorney Adam Welch appears with the defendant. He appears in person. In custody. We've received a copy of the complaint. The address on the complaint is no longer valid. Mr. Urquiza Duran will be receiving mail at the Beacon, 615 East Washington Avenue in Madison. He is eligible for a public defender. And we would enter not guilty pleas to the charges in the complaint.
Right, I've reviewed the complaint. It contains probable cause with those not guilty pleas entered. What's the state's position on bail or bond?
Yes, Your Honor. The state would ask for $1,000 cash bond, a condition of well, I guess I should say, before I continue the recommendation, the victim asked my office to share the following on their behalf, if I may.
Sure.
And this is according to the victim. In addition to what the state is recommending, I would like to also request a ban from the 4500 block of Atticus Way and a ban from the 2000 block of Red Arrow Trail in Madison because the defendant hangs out in this area that is very close to where I live. I fear leaving my house, especially at night, because there are a lot of trees in the area where someone would be able to hide out. There is already a case open where he has bail conditions to not have contact with me and a ban from the 4600 block of Atticus Way. And this new case shows he is not following his rules. I just want him to stay away from me and where I live.
They told me that it was 7 floor, that's in Atticus, the apartments, but I live on the other side. Okay. As a main company. They're all on the one bed. Atticus. But we need 500 Atticus y dos let's. You understand? Yeah. Okay.
Thank you, Your Honor. We're all set.
Yes, Your Honor. And in addition to the $1,000 cash bond, the state is also asking for no contact with Armando L.H. and a ban from the 4600 block of Atticus Way and a condition of no dangerous weapons. The reason for the state's requests are that the defendant was released on a signature bond on July 9th of this year with the same conditions that the state is recommending now. As alleged, the defendant violated all 3 conditions, and as alleged, he continues to threaten the victim. The state would respectfully ask for cash bond. Technically, this is an Act 3 offense, I think, with a dangerous weapon, but it's a misdemeanor offense, the state will note. But cash bond would also be necessary to ensure the defendant's future appearance in court. And the state has no further argument.
Counsel, on behalf of Mr. Duran.
We would be requesting a signature bond here. The defendant is currently unemployed. He is without housing and says he's been sleeping outside. So he does not have any resources to post a cash bail. He does have a history of doing contracting work, but has been out of work for over a year. He told me just now that he believed that the geographical ban was a 72-hour order, which I think is a common misunderstanding, especially for someone with limited experience with the justice system, and who hasn't yet been appointed an attorney who could explain these things to him. With the assistance of the interpreter, we have clarified the scope of the existing bond conditions. So I believe he does understand that he's not allowed to be on that block at all.
That's fine.
So given the nature of these charges and the defendant's indigency, we believe a signature bond would be appropriate.
All right, the complaint alleges not only that Mr. Urquiza Duran was in an area where he was not permitted to be, but that he was also in possession of a kitchen knife after having been banned from possessing dangerous weapons. I think there's some reason to be concerned that he is not likely to follow bail conditions designed to keep the community safe and not likely to come to court as required. that some cash bail is appropriate, given those circumstances. I will order it in the amount of $250. While this case is pending, sir, I will order that you not have any contact with Armando L.H., that you not possess any dangerous weapons, and that you not be in the 4600 block of Atticus Way. Counsel, does Mr. Urquiza Duran have any position with respect to the request that he also be banned from 4500, the 4500 block of Atticus Way?
Oh, I'm sorry, I didn't understand the distinction there. Is that what the state's asking for, is
This-
two different blocks?
That was the information the victim asked us to read on their behalf. I don't know the reason for the discrepancy between 4500 and 4600. If it was just a mistake, because since they're so close to one another.
I have to not be along with the permits to study. So. Things at the ones that are as possible and set this way, it's just so it's as fully sales system. Not for that for the meetings, the same post, not for this. And then you also or you know, those songs done in like other for the meeting. E and was it also 46 and 45, 100, 2,000, whatever. I understand. You okay with that? Yeah. Okay.
We're fine with all that, Your Honor. There's also the request for a red arrow trail. I don't know if the court's ordering that.
Frankly, it looks like Atticus Way is a pretty short street, so I think that the bond condition will just be a ban from Atticus Way.
That makes sense. It's just an apartment complex, basically.
All right.
That way.
Next is Devin Wilson, appearing via Zoom.
That's everyone for our improvement. Thanks everyone for our improvement.
Thank you. There was another one named Oscar Castillo, but maybe not.
Yeah, he's on the list.
Yes, he has an open case and does not need an interpreter of the open case. Okay, good, thank you. Okay.
This is Mr. Bolton.
Oh, I didn't realize it was by Zoom. Okay, this is 26 CM 1854, State of Wisconsin versus Devin Wilson. Appearances, please.
88 Carl Lazarus for the state.
Attorney Adam Welch from the Public Defender's Office appears on behalf of Mr. Wilson. Mr. Wilson, is that you on the video?
Video. What video are you talking about?
Are you Devon Wilson?
What'd you say?
I'm asking if you're Devon Wilson.
On the camera up there, yeah.
Okay. Did they give you a copy of what you're charged with?
Let me see, yeah.
Okay. They list an address on 64th Court in Milwaukee. Is that current?
No,
Okay. Do you have a current mailing address?
Aberg.
Okay. Your Honor, Mr. Wilson appears in custody by Zoom video from the jail city county building. He is appearing crouched down through a food slot. He has been provided a copy of the criminal complaint. The address is not accurate. We would ask that the court use 1819 Aberg Avenue for a mailing address. We would waive any reading of the complaint, stand mute to the charges, and he has not yet been evaluated for a public defender on this case.
All right, thank you. I reviewed the complaint, find that it states probable cause under not guilty pleas on Mr. Wilson's behalf. I see that there's a public safety assessment report on file. but don't see that it contains any recommendations. I don't know if that's intentional or not. Is there anybody from that pretrial assessor who can tell me? Okay, maybe not. I suppose I'll just get the state's recommendation.
Yes, the state would ask for a $500 cash bond with a ban from the State Street and Langdon Street map area. The reason for that request is, I believe this is the 5th pending case, and I think these cases have occurred just over the last couple of months. I believe when the defendant was arrested, he maybe had a copy of his bond in one of the previous cases indicating the banned area. And then allegedly the defendant resisted arrest. So we believe that some amount of cash bond is appropriate given the increasing number of charges and unlikelihood to attend court. However, I'll note, I'm not aware of any missed court appearances or if there have even been any court appearances scheduled since the first of the 5 cases occurred.
All right, thank you. On behalf of Mr. Wilson.
Thank you, Your Honor. I believe Mr. Wilson does have a misdemeanor record, no felonies, and he does not have any recent failures to appear. I don't believe any of these current cases are violent offenses. Certainly the ones before the court today are not. And it appears that what's going on here is that Mr. Wilson is unhoused. He was told not to be in the State Street area. And from my reading of this, he wasn't bothering anyone or doing anything that was, harming anyone, but the officers just recognized him from previous arrests and didn't want him on the State Street area, so they arrested him. I understand that enforcing compliance with the court orders is something that has to be done at a certain point. I don't know if just arresting someone over and over again is doing anyone any good. But I don't think there's anything here suggesting that he's not likely to appear in court. And I would ask that the court issue a signature bond for Mr. Wilson.
Thank you. I just had a chance to quickly review some of these cases on CCAP, not all of them. I didn't see any missed court appearances, and but as you indicated, Attorney Lazarus, there haven't been a whole lot of required court appearances. There have been some in 26 CM 348, which looks like it's still pending. It does look like Mr. Wilson has made at least one appearance on that case. And it maybe wasn't at another appearance, but it says it was excused. Oh, is that a different Devin Wilson?
We currently have 2 Devin Wilsons that have several pending cases.
Okay.
This is Devin A. Wilson.
Thank you. Let me see if I can find. Okay, although that was the wrong Devin Wilson, doesn't look like the facts have changed much. It seems like Mr. Wilson does not have any recent history that I can see immediately anyway of having missed court. I think a signature bond's appropriate given that. I will order that while this matter is pending, Mr. Wilson, you are banned from the area depicted on the State and Langdon van map. All right, we're turned on that case.
Next is Carl Mosby. Mosby? Stay on the yellows.
This is 26 CF 1724, State of Wisconsin versus Carl Mosby. Appearances, please.
ADA Carl Lazarus for the state.
Attorney Adam Welch from the Public Defender's Office appears with Mr. Mosby. He appears in person. We have received a copy of the criminal complaint. We will waive its reading. The address on the complaint is accurate, and Mr. Mosby does qualify for a public defender.
I'm going to take just a minute to review the criminal complaint on this one. All right. I reviewed this complaint. It contains probable cause with respect to Mr. Mosby. What's the state's position on bail or bond?
Yes, Your Honor. The state would ask for cash bond in the amount of $2,500, conditions of no contact with the co-defendant, no contact with the Maya B or Shannon H, a ban from Salon Centric, and a ban from the 1600 block of Thayer Road, and no use or possession of controlled substances or drug paraphernalia. The reason for these requests are one of these offenses is an Act 3 offense, the robbery. Also, as alleged, Mr. Mosby was on bond at the time for or in 26 CF 1482, which alleges a substantial battery, another Act 3 eligible offense. And then Mr. Mosby had been, I believe, released from custody in that case about a month ago on July 7th. Given the continuing number of cases that are being filed, including, I think, 2 other cases that are on file, which are misdemeanor cases, both disorderly conducts, the state believes that cash bond is appropriate, and this amount of cash bond is necessary to ensure Mr. Mosby's future appearance in court and also to protect the public under an Act 3 analysis. The state has no further argument.
The argument on behalf of Mr. Mosby.
Your Honor, I'm going to ask for a signature bond on behalf of Mr. Mosby. He has resided in this community his entire life. I don't think he presents a flight risk. He's currently unhoused. He's been homeless. He's been unemployed. He does not have any steady income right now, so would not be able to post a cash bail. I would note that I know the court reviewed the complaint. I'm not challenging probable cause. I would, however, note that I think, there's different sort of, I guess, degrees by which somebody could threaten to use force. This is not a case where there was any explicit threats made, as far as I can tell from the allegations. They're not alleging threats of violence. They're not alleging the use of any violence. Basically, what it sounds like is an allegation of a sort of retail theft where it's alleged that Mr. Mosby sort of snatched the item away from the employee. For probable cause purposes, yes, that would constitute the use of force, but I think it's very different than a robbery allegation where somebody is, hitting someone, threatening someone, verbally, displaying a weapon. I guess that would be an armed robbery in that case. But I think this is fairly mitigated as far as these allegations go. I think under the circumstances, a signature bond or at least a lesser amount of cash would be appropriate.
All right, thank you. Well, the allegations in the criminal complaints are that Mr. Mosby committed a robbery while on bond. I think this is an Act 3 eligible offense, and it demonstrates that some cash bail is necessary to protect the public from Mr. Mosby. I will order it in the amount of $1,000. While this case is pending, I will order that Mr. Mosby have no contact with Jessica Nobles, that he not be at Salon Centric or in the 1600 block of Fire Road, that he not possess any controlled substances or drug paraphernalia. And Attorney Lazarus, I'm sorry, I missed the two other individuals who you requested the no contact with.
Yes, Your Honor. Amaya, Amaya, last initial B, and Shannon H.
So also order the no contact with Amaya B and Shannon H. Should we schedule the matter for a timely preliminary hearing?
Yes, please.
All right, that's what we'll do. Mr. Mosby, you'll get the date for the preliminary hearing when you leave here. We're adjourned on this case.
There's a job here on the next court date. And
Next is Delvin Manipon, you're gonna be a Zoom.
best things from there, okay? Yes. All right, so go right this way, please. This way.
I'm sorry, who is the next?
Sandoval.
Mendenhall.
This is 26 CF 1723, State of Wisconsin versus Delvin Manavong. Appearances, please.
ADA Carl Lazarus for the state.
Attorney Adam Welch from the Public Defender's Office appearing in court. Is that Mr. Manavong on the video, sir?
Yes.
Okay.
Yes.
Sir, did they give you a copy of a criminal complaint charging bail jumping, disorderly conduct?
Yeah.
Okay. That complaint has an address on Straubel Court in Madison. Is that your current address?
Yes.
Okay. Your Honor, as alluded to, Mr. Manavong has received a copy of the complaint. We will waive its reading. The address is correct. He does qualify for public defender representation.
Thank you. I've reviewed the complaint and find that it states probable cause. What's the state's position on bail or bond?
The state would ask for cash bond in the amount of $1,000. Condition of ban from State Street, according to the map, our ban map, and no contact with Officer Belanger, except in his official capacity. The reason for the requests are, I believe the defendant is on bond for battery to a law enforcement officer. And here, at least as alleged, there's some, I guess, ongoing animosity toward the police officer with the allegation that he struck a police vehicle with his hand, and also an allegation that he violated bond. But we would make those requests with no further argument.
Was the request for $1,000, Cap?
Yes, Your Honor.
Okay. Attorney Welch?
Your Honor, Mr. Manavong is a lifelong resident of this area. He does have an apartment. He has somewhere to live. He is currently unemployed. I think he posted $500 recently, but my information suggests that he probably would not have resources to post any additional bail at this point. He's not working. I do not believe there's any history of failing to appear in court. And as charged, I don't believe that these are Act 3 eligible offenses. So I would ask the court to consider a signature bond for Mr. Manavong.
All right, just 1 second, please. All right, thank you. Well, it's alleged that Mr. Manavong, while on bond, for a charge of, battery to a law enforcement officer, allegedly walked up to a law enforcement officer inside a vehicle and, punched the vehicle. I think given the previous case, which was Act 3 eligible, and these facts, I think there's a reasonable concern that Mr. Manavong is not going to come to court as required. It looks like maybe the bond in that case had just been amended to a $500 cash bond, which Mr. Manavong posted and hasn't had any required appearances since then. I think that $500 is the appropriate amount of cash in this case as well. That's what I'll set. With respect to the time limits for the preliminary hearing,
We'd like it within the time limits, please.
we'll schedule the matter for a timely preliminary hearing. I will also order the conditions requested by the state, which is that Mr. Manavong be banned from state 3. And no, I'm sorry, I was just making sure it was state 3. It was state 3, right?
Yes.
Yes.
And no contact with Officer Bellinger except in his official capacity. All right, we're here.
Next is Oscar Castillo. Oscar Castillo. Paperwork. Sir, please stand with your legs.
26 CF 1721, State of Wisconsin versus Oscar Castillo. Appearances, please.
ADA Carl Lazarus for the state.
If I could just have one moment.
Affirmative, that's good. So you already done that? Yes, so we've been in contact with unable to make. That's pay off. That's already done. Yes, sir. Okay, great. Please do that.
Okay. And I have 2 different addresses for you here. Are you still on the Hamburg?
Negative.
Mulligan,
Affirmative, that's correct.
6014
Yes.
South Mulligan, 60638.
Yes, sir.
Thank you for giving us a moment, Your Honor. Mr. Castillo appears in person and in custody. Attorney Adam Welch from the Public Defender's Office appearing specially on his behalf today. I believe he has retained or is in the process of retaining an attorney for this case. But he does want me to represent him especially for today's purposes only, which I will do. He has received a copy of the complaint. We will waive its reading. I have an updated address for him. 6014 South Mulligan Street Avenue, South Mulligan Avenue, Chicago, Illinois, 60638.
All right, thank you. I've reviewed this complaint. It contains probable cause. What's the state's position on bail or bond?
Yes, Your Honor. The state would ask for $2,000 cash bond, conditions of no contact with Lucero M. or her daughter. A condition of no alcohol and a ban from the 1800 block. Yes, 1800 block of South Stoughton Road. The reason for these requests are, it's the state's understanding Mr. Castillo now lives in Chicago, out of state. Here, I believe Lucero M is the victim in the first case. I'll verify that, but that would be 25 CF 2671. I believe that case is still open. I think there was a DPU plea to count 1 in that case, which was a strangulation with Lucero M. That strangulation is not only an Act 3 offense, but an offense still pending on bond and an offense that Mr. Castillo has actually, it's my understanding, entered a guilty plea to already. Granted, he's in the deferred prosecution program. Here, it's alleged that Mr. Castillo committed a second-degree recklessly endangering safety, again, against Lucero M., a battery, and then the felony bail jumping. I think two of those, the battery and the second-degree recklessly endangering safety, are Act 3 offenses. Mr. Castillo is still on bond for an Act 3 offense against the same victim, strangulation. And then, as I mentioned, Mr. Castillo lives in Illinois. There is a concern under an Act 3 analysis, as mentioned, and somewhat of a concern. I say somewhat because I'm not aware of any failures to appear, but with residing out of state with these kinds of charges pending, there's a concern of whether or not Mr. Castillo will come to court without a sufficient monetary bond posted to ensure his future appearance. And for those reasons, we would ask for that amount of cash bond with those no contact conditions.
What about the request for no contact with the daughter? Is this a shared child?
I don't know the answer to that, Your Honor, but I can find out the answer in a moment. And defense counsel may have that information. I don't know.
Yeah, it is, and I can speak more to that.
Okay, before you do that, let me find out what the reason for the request with the no contact with the shared child is.
Yes, Your Honor. I'll
I read the
check.
complaint. Is it just that she was in the vehicle?
I will check if I may just have a moment. May I just have just one more second?
Yes.
Be very quick. Um, Yes, so it's my understanding the victim agrees with these recommendations, and that specifically as it relates to the no contact with Lucero M's daughter, it's because the daughter in question allegedly witnessed the entire situation and was very frightened by this incident, given its alleged level of severity. And those are the reasons for all of the state's requests.
All right, Attorney Welch?
Thank you. We are requesting a signature bond. We are also objecting to the request that Mr. Castillo be banned from having contact with his daughter. First of all, I think some context for what happened here, and I'm just going off of what's alleged in the complaint. But based on what's alleged in the complaint here, it looks like what happened was, as alleged, Mr. Castillo was meeting up with his ex, the mother of his daughter, at a arranged location with her agreement. So there's a bail jumping charge in here for being at this parking lot that he was banned from in the previous case. Whether that charge sticks or not, I think it's important to be aware that this is something that was mutually agreed upon. And that if there was a violation of that specific bail condition, it was with LAM's consent, essentially. Not that that's a defense necessarily, but that's context. Secondarily, what it appears happened here is that there was a child custody exchange, that Mr. Castillo left the scene, was chased down by his ex, who rammed into his car, went in through the passenger side window, and started a fight with Mr. Castillo's, I believe, current partner. Mr. Castillo's alleged involvement in this is that when this was happening and his ex, LAM, was leaning in through the window, assaulting his current partner, he tried to drive the truck away. And that's the basis for the recklessly endangering safety allegation. Now, whether that charge sticks or not, I guess, we're not here to debate that today. But I think it's important to point out that this appears to be charges based on a situation where Mr. Castillo was meeting up where he was supposed to be meeting up to get an agreed upon childcare exchange, that a fight was started between two other people, and that Mr. Castillo was trying to leave the situation. Mr. Castillo is originally from Chicago, Illinois. He's been a firefighter in Madison for the past 11 years. Had a solid career. He believes he's now lost that job. The address we provided is his family's address, his parents in Chicago, which is likely where he's going to end up since he's now presumably unemployed. But he is a person who has been stable in this community for a long, long time, a person who has a stable place to go to. He did have a prior case involving LAM. There were no failures to appear in that case. It looks like he handled everything as he was supposed to through the court system in that case. There is a divorce pending right now. Mr. Castillo informs me that the child custody arrangements were still being finalized. I imagine, based on my experience in dealing with these kind of situations, that there will probably be some action in the family court case involving custody. I would ask that this court not kind of put its fingers on the scale there and simply order that Mr. Castillo abide by whatever custody and placement orders are issued in the family court case. If it's determined through the family court process that he should not have custody with his daughter right now, fine. But I think that that's the venue that will have the most information and the most ability to make a proper decision, taking into account the best interests of that child. And I would ask that this court simply defer to that court. So that's my argument. Thank you.
All right,
Yes.
thank you. With respect to the non-monetary conditions, I will order no contact with Lucero M. I will order that Mr. Castillo not possess or consume any alcohol, and that he not be in the 1800 block of South Stoughton Road. With respect to the issues of contact with the daughter he shares with Lucero M, I tend to agree with Attorney Welch here that that the contact between Mr. Castillo and his daughter be simply as ordered in 25 FA 1384. The harder question is the issue of cash bail. Certainly, if the question were just whether Mr. Castillo were going to appear in court as ordered, I think that I would agree that a signature bond is appropriate. But what's alleged here is that he was out on bond for strangling Lucero M, and then engaged in the conduct that is described in the criminal complaint, which I won't rehash, but endangered her safety while their shared daughter was present. It's an Act 3 eligible offense. The case that was pending at the time is an Act 3 eligible offense. I do think that there are some, I think that cash bail is warranted under an Act 3 analysis to protect the public. I will order it in the amount of $1,500. With respect to the time limits for the preliminary hearing, counsel, and I'm sorry, Attorney Welch, I didn't hear whether you said that Mr. Castillo was eligible for public defender or not.
He hasn't been evaluated, but I believe at this point it's his intention to retain counsel, so he hasn't wanted to be evaluated yet.
Okay, then with respect to the preliminary hearing.
Waive the time limits.
All right, I'll find Mr. Castillo's waived the time limits for the preliminary hearing. We'll schedule the matter for a status. Mr. Castillo, you'll get, when you leave here, you'll sign your bond form and you'll get the status date. You have to come back whether you have an attorney or not. And I didn't say it already, you have a right to be represented by an attorney, since you're charged with a crime. If you don't qualify for a public defender, or you don't end up retaining an attorney, but you don't qualify for a public defender, your options are to hire an attorney to represent you or to ask the court to appoint a lawyer for you. And Attorney Welch is going to give you some information, I think, about where you can contact the public defender. All right. We're adjourned on that case.
All right, good luck.
Next is Tobias Baker appearing via Zoom for a forfeiture.
Good afternoon. Are you Mr. Baker?
Yes, I am, Your Honor.
All right, I'll call 26FO1506 Dane County versus Tobias Baker. Appearances, please.
ADA Carl Lazarus for the county. Mr. Baker appears in custody via Zoom and without counsel.
Mr. Baker, I have in front of me a forfeiture complaint. It charges you with 1 count of county possession of THC. This is a non-criminal offense. It carries no potential jail sentence, just a forfeiture of money only. I'm going to ask you how you wish to plead to this, but before I do, I want you to know a couple of things. First is that no matter what your answer to that question is, you will be released from jail. This carries no potential penalty. It's not going to hold you any longer. I don't have any information that you're being held on anything else. The second is that sometimes the county wishes to make an offer to resolve these sorts of cases today. Would you like to hear the offer from the county?
Yes, Your Honor, I would, but just one question. If it's resolved today, would I be pleading out to a felony? Because the officer wrote it up as a felony.
No. Mr. Baker, I'm sorry, maybe you missed the part where I said this is a non-criminal ordinance violation. So
Okay,
there's no
all right, yeah, I
no
did miss that part.
felony,
Sorry.
no misdemeanor, no crime. Attorney Lazarus, what's the county's recommendation?
Yes, the county would resolve this matter for a plea of no contest for court costs only.
So, Mr. Baker, if you wish to enter a no contest plea to this ordinance violation, I'll order that you pay court costs, $114.50. I can give you a couple months to pay that. How would you like to plead today, sir?
I would like to plead no contest, Your Honor.
I'll find you guilty based on your no contest plea. I'll order that you pay court costs of $114.50. I'll give you 60 days in which to pay that.
Oh, okay.
We're adjourned on that case.
Next is Justin Allen.
Justin Allen, appreciate your work, sir. Please stand in the audience.
This is 26 CF 1720 State of Wisconsin versus Justin Allen. Appearances, please.
ADA Carl Lazarus for the state.
Attorney Adam Welch from the Public Defender's Office appears with Mr. Allen. He's here in person and in custody. We have received a copy of the complaint. We will waive its reading. The address on the complaint is accurate. He does qualify for public defender services.
And I reviewed this complaint. It states probable cause. What's the state's position on bail or bond?
Yes, Your Honor, may I just have one moment? Yes, Your Honor. The state would ask for a signature bond with the condition of no contact with child victim, whose initials are JJJ, and also no contact with another child who's the younger sibling of JJJ, who is JRJ. The reason we are asking for the no contact conditions largely have to do with what's alleged in the criminal complaint. It's my understanding that this assault allegedly occurred on video and was somewhat, I guess, public in that at least one person witnessed it. And then again, it was captured on the video camera or video surveillance at the location. The child is currently, I believe, 6, which is, I guess I would argue, a more vulnerable age than if the child was significantly older than 6. Also, the other child that we're asking a no contact for is only 4 years old. The state believes that no contact with these children is appropriate, just from protection of the public. I would assume there'll be ongoing, if Your Honor granted that request, the defendant would certainly be free to challenge that bond condition at any number of future hearings on the matter. And in the alternative, if Your Honor does not grant no contacts as requested, we would ask that Your Honor at least grant a condition, no unsupervised contact with any child under 17.
Attorney Lazarus, I read the complaint. It sounds like this child, JJJ, was at work with Mr. Allen. Suggests to me that maybe there's no one else to care for the child. Do you have any information about where the child who will take care of the child if Mr. Allen does not?
I can try and get that answer right now.
I can give a little info on that, Your Honor, if that's all right.
Sure.
Okay. And I don't want to cut off Mr. Lazarus if he has more info. But Mr. Allen tells me that the children's biological mother is not really in the picture right now, but they are staying with their godmother right now. That is a stable place and that they are safe and the godmother can look after them for the time being. So it's not a kind of crisis scenario. Mr. Allen also tells me that he has been in touch with CPS, so there's already been a referral. They've, I assume, came up to see you in person here. They came up to see him in person at the jail, and they're recommending that he not have any contact for the time being. I assume there would be a ongoing protection services kind of situation there where he might be able to get contact back at some point, but that's what they're recommending right now.
What's Mr. Allen's position on the no contact?
Our position, Your Honor, would be that the court order that he comply with any CPS orders regarding contact with the children. That sort of leaves it up to CPS to kind of do a graduated, supervised visitation schedule or something like that without having to come back to the criminal court every time and get a modification of bail.
Attorney Lazarus, any additional information or any thoughts about the proposal that I ordered that that Mr. Allen comply with any CPS orders rather than a blanket no contact?
I guess then, yes, it would, we would maybe amend our request for no contact with either child until given permission by CPS. The other information I have is consistent with what Attorney Welch said, that if and when Mr. Allen is released from custody, the children, at least for the time being, would not return to his custody before being cleared with Child Protective Services. And so maybe the state's asking for the same thing effectively. But yes, we would ask for no contact unless with the approval of CPS, and only then, I guess, no unsupervised contact with any child.
Are you, Welch, do you want to make any, I'm not sure you made a general bail
No,
argument.
I think we're, yeah, I don't have any other general arguments. I guess our requested language would just be that he comply with any CPS orders regarding contact or custody of the children. But I think we're fairly close to recommending the same thing.
Thank you. I'll order a signature bond in this case. While this matter is pending, Mr. Allen, I'm going to order that you not have any contact with JJJ or JRJ unless permitted by CPS. With respect to the time limits for the preliminary hearing, counsel?
We'll waive the time limits, Your Honor.
All right, I find that Mr. Allen's waived the time limits for preliminary hearing. We'll schedule the matter for a status. Mr. Allen, when you leave here, you'll sign your bond form and you'll get your next court date. Make sure you come back to court whether or not you have a lawyer on that date, okay?
Yes.
All right.
Okay, go with them.
Register. Next is Purcell Sweeney. Purcell Sweeney. Please stand in the audience.
Thank you, sir.
This is, okay, this is 26 CF 1727, State of Wisconsin versus Purcell Sweeney. Sweeney, thank you. Appearances, please.
ADA Carl Lazarus for the state.
Attorney Adam Welch from the Public Defender's Office with Mr. Sweeney. He appears in person and in custody. If I could just have one quick moment. I have an updated address for Mr. Sweeney. 6733 Schroeder Road, Apartment 1, Madison, Wisconsin, 53711. And he does qualify for public defender representation.
Thank you. I've reviewed this complaint. It states probable cause. What's the state's position on bail or bond?
Yes, may I just have one quick moment? Yes, the state would ask for cash bond in the amount of $3,000, condition of no contact, direct or indirect, with Eddie H. and a ban from the Ella Apartments in the 2800 block of East Washington Avenue in Madison, and a condition of no operating a motor vehicle without a valid driver's license. The reason for those requests are that it's my understanding that Mr. Sweeney already has 4 pending cases, which are mentioned in the criminal complaint, specifically 26 CF 880, 26 CF 951, 26 CF 1485, and then this case, and I might have left one out, 25 CF 2278. There are no Act 3 allegations for this recent case. Some of the cases the defendant has pending are Act 3 eligible, but again, none for this current case. I'm not aware of any failures to appear in those four pending cases. I'd have to look into CCAP, and I don't know if there was a public safety assessment completed here. But the state's main main reason for those requests are that this is now the fifth pending felony case in a relatively short period of time. There are concerns about Mr. Swinney being able to follow the rules of his bond, and that also is concerning for future appearance in court. So we would ask for these conditions and that amount of cash bond.
There is a public safety assessment on file. It recommends some modest cash bail and notes. No failures to appear pre-trial in the last 2 years, but some failures to appear that are older than that.
Thank you for that information.
Counsel, on behalf of Mr. Swain? Sorry.
Mr. Swinney's resided in this area his entire life. He has strong ties to the area. He's does have an employment history, but has been out of work for about a year, so he doesn't really have any resources to come up with cash bond right now. I think what the state's asking for here is a bit excessive. This is not Act 3 eligible offenses. This is nonviolent. This is a property crime allegation where it appears there, may be dispute over whether consent was given or not to operate this vehicle. But I don't think there's anything in this complaint or from his recent history that would suggest that he wouldn't appear in court, which is the primary question on the table today. So I'd request a signature bond for Mr. Swinney.
All right. Thank you. Just looking at CCAP, it looks like Mr. Swinney does not have any, just as is indicated in the pretrial assessment report here, that there are no failures to appear pretrial in the last 2 years, although there are some older than that. Mr. Swinney has quite a few open cases. I think that there's some reasonable concern that if he is committing crimes while out on bond, he's not likely to come to court as ordered. Given the circumstances, I will order cash bail in the amount of $300. While this matter is pending, Mr. Swinney, no contact with Eddie H. And you're not to be at the Ella Apartments. Attorney Lazarus, was the state asking for a ban from the 2800 block of East Washington Avenue? We're just noting that the Ella Apartments is on the 2800.
I think the latter, Your Honor.
Then you're not to be at the Ella Apartments on East Washington Avenue. And not to operate a motor vehicle without a valid driver's license. Time limits for the preliminary hearing, counsel.
We'd like the hearing within 20 days, please.
All right, we'll schedule the matter for a timely preliminary hearing. We're adjourned on this case. I need just a few minutes before the next one. Sure.
Okay, go with them.
Billy Fields. Billy Fields. Go, sir. Please stand in the LX.
Right here, sir.
This is 26 PM 1849, State of Wisconsin versus Willie Fields. Appearances, please.
ADA Carl Lazarus for the state.
Attorney Adam Welch appears with Mr. Fields. He appears in person and in custody. We've received a copy of the complaint. We'll waive its reading. We'll stand mute to the charges. The address on the complaint is correct, and he currently does not qualify for a public defender going forward, but I will represent him for today.
All right, Mr. Fields, you've been charged with a crime. So you have a right to be represented by an attorney. It sounds like maybe you don't qualify for an attorney through the public defender's office. So your options are to hire an attorney to represent you or to ask the court to appoint an attorney to you. All right, I've reviewed this complaint. It contains probable cause. I'll enter those not guilty pleas on Mr. Fields' behalf. What's the state's position on bail or bond?
The state would ask for a $1,000 cash bond with a condition of no contact with Shirley M. The reason for those requests are this is the fourth pending case. I think Shirley M, the no contact condition, is related to the three pending cases right now. I think $500 cash was posted in 26 CM 1534 on July 7th of this year. So an increase in cash, in the state's opinion, is appropriate. And I believe those are, that's the entirety of the state's argument.
Shirley M or Shirley C?
I have M. Was I?
It's M-C according to.
Oh, okay.
C.
Then yes, then that. Thank you.
That's because the other cases say no contact with Shirley C.
Oh, okay.
Okay. Your Honor, I'm requesting a signature bond on behalf of Mr. Fields. The factual allegations here are. Is Tommy your son or who's Tommy?
Nice.
Okay.
No.
Okay. So Mr. Fields, who is 78 years old, retired from the US Postal Service, and doesn't qualify for public defender representation due to his pension, essentially, owns this house on Portland Parkway. He has previous cases involving Shirley C. Shirley C was at the house. He's not supposed to have contact with her, but she was at the house. The person identified in the complaint as TP, who is a good friend of Mr. Fields' son, is the one who contacted the police to try to get Shirley out of the house, and she was refusing to leave the house. So Mr. Fields is now the one who gets arrested and is charged with bail jumping, even though it appears that the people who have a lawful right to be in the house were trying to get her out of the house and she was refusing to do that. I personally don't think he should have been arrested or charged in this. Technically, there is probable cause, but I don't think a cash bail is appropriate here.
Okay. The complaint alleges a little bit more than just she was refusing to leave the house. It also alleges that she was living there and that Mr. Fields had been engaging in a relationship, I suppose, for lack of a better word. But Mr. Fields, I saw you last month when I think you and Shirley C had been in a vehicle together at that point. At that point, I found that a signature bond was appropriate. I don't see that you've had any opportunities to be in court since then, so I'm going to find that a signature bond is appropriate in this case too. I just don't think there's any reason to believe that you're not going to come to court. And I suppose if you continue to violate the rules of your bond, at some point, you know, you'll have to deal with that, but as far as whether or not you're gonna come to court, I don't really see any reason to believe that you're unlikely to do that. Mr. Fields, if you want Shirley C out of your house, I assume that I would encourage you to contact law enforcement before before the two of you are in your house together. You don't have to explain it to me, I'm just offering you a bit of unsolicited information, I guess. So we're gonna be adjourned on this case. Good luck.
Thank you. Next is Kellyanne Keeler, appearing via Zoom.
Oh, Your Honor, I think I need to talk to Ms. Keeler before we go on the record. Maybe we can just get that started right now.
Sure.
The private conversation?
Yes, if we can.
I was informed by the bailiff, that the resident informed the bailiff she was not gonna participate in the proceeding.
Oh, okay, so she probably won't participate in talking to me either.
Maybe we could ask her, or the bailiff over there could ask if she wants to talk to the attorney first. As to the CCB?
Yes.
Okay.
Yeah.
You know. Especially those,
All right, this is 26 CF 1716, State of Wisconsin versus Kellyanne Keeler. Appearances, please.
ADA Carl Lassers for the state.
Attorney Adam Welch from the Public Defender's Office is with Ms. Keeler. She appears by Zoom video. She's in the city county building, appearing by Zoom. We have received a copy of the criminal complaint. We are going to waive its reading. The address on the complaint is accurate. She does qualify for a public defender. We are going to be raising competency, but I would ask that we address bail first.
All right, thank you. I've reviewed this complaint. It contains probable cause. What's the state's position on the issue of bail or bond?
The state would ask for a signature bond with a condition of a ban from Baymont Inn and Suites locations.
On behalf of Ms. Keeler?
No objection to that.
All right, I'll order a signature bond. While this case is pending, Ms. Keeler, you are banned from any Baymont Inn and Suites location. Given the representations made by counsel, I find that there's reason to doubt Ms. Keeler's competency in order that an evaluation be completed. The proceedings will be suspended.
Attorney Welch, do you happen to have a contact number for Ms. Keeler for the Wisconsin Forensic Unit?
Yes, I do. Can we give that off the record? Okay, but I do have. Oh, she's saying something, but I can't hear her.
I'll get that.
Okay.
You're off the record. It's all right. We're here now.
Okay.
I'm just gonna utilize that for-
Okay. I didn't say it, we're adjourned on that, on the Keeler case.
Okay.
How about a doctor doesn't have accommodations here? That's it's all of you.
Melvin Jackson's next.
Melvin Jackson. Different, please say on your lights.
Just a little bit right there. There you go.
This is 26 CF 1719, State of Wisconsin versus Melvin Jackson Jr. Appearances, please.
ADA Carl Lassers for the state.
Attorney Adam Welch from the Public Defender's Office appears with Mr. Jackson. We've received a copy of the complaint. We will waive its reading. The address on the complaint is accurate. However, I am going to move to dismiss. I believe the complaint lacks probable cause. Can I go ahead with an argument on that?
Can you just hold on for a minute? I don't think I read this one before I came down here. So if you'll give me a minute just to review the complaint and then I'll invite you to make.
Sounds great.
your
Thank you.
arguments. Whenever the two of you are ready, I'm ready.
Thank you, Your Honor. So, you know, what we have here is a possession of cocaine charge, and then we have a bunch of bail jumping charges, but those are all just derivative of the cocaine possession. So it really comes down to whether the state has sufficiently alleged that Mr. Jackson knowingly possessed a controlled substance, cocaine. My reading of the complaint is that cocaine was found in the closed center console of a vehicle that Mr. Jackson was driving. The vehicle was not registered to Mr. Jackson or owned by him. He was driving it. They spoke with other members of or passengers of the vehicle. None of them made any statements suggesting that Mr. Jackson knew of the cocaine. Mr. Jackson himself didn't make any statements suggesting that he knew that there was cocaine in the vehicle. So I would suggest that the state has not sufficiently alleged knowing possession of cocaine. It's not enough to simply allege that it was there within his reach. If he didn't know it was there, he didn't possess it.
Attorney Lazarus, in response?
Yes, Your Honor. The state would just submit there is probable cause based upon the defendant operating motor vehicle and thereby being inside the motor vehicle that also contained the cocaine. It looks like there was cocaine found in a Newport cigarette pack in the front passenger door portion. And then there was cocaine found in a gold metal cylinder, also in the front passenger door portion of the vehicle. And then lastly, cocaine found in a rubber case in a small black bag, as defense counsel indicated, in the center console of the vehicle. The state would submit that the close physical presence, including the center console, that there is probable cause to support the charges.
Right. The complaint to the case that there was a bag here in the center console of the vehicle, which was directly next to where the defendant was sitting and very easily within his reach. There's some descriptions about where everyone else was seated in the vehicle. I think there's a reasonable inference here from the facts that any or all of the car's occupants have knowledge of and exercise dominion control over the cocaine. I think it's sufficient for probable cause. Beyond that, I won't speculate, but as far as probable cause goes, I think what's contained here is sufficient. Having found probable cause, I'll turn to the state for its recommendation.
Yes, Your Honor. The state would ask for $500 cash bond. And a condition of no controlled substances or drug paraphernalia without a valid prescription. The reason for those requests are, I believe there are now a number of pending cases. And in one of or maybe the most recent pending case, cash bond was set at $150. So the state is asking for an increase in that to the amount requested with no further argument.
On behalf of Mr. Jackson.
Your Honor, this is not an Act 3 eligible case. This is a nonviolent case. This is a simple possession case. It would be a misdemeanor, but for the fact that he's on felony bail for other charges. He has been appearing in court as required on the other pending cases. He has an attorney. He's been compliant with appearing in court. I don't think there's anything here that suggests that he would not appear in court as directed. I think a signature bond is appropriate.
All right. Without any information that Mr. Jackson has been failing to attend his court appearances as required, I agree that a signature bond is appropriate. That's what I'll order. Mr. Jackson, while this case is pending, you are not to possess or consume any controlled substances without a valid prescription, and you're not to possess any drug paraphernalia. With respect to the time limits for the preliminary hearing, Counselor,
Waive them.
I'll find Mr. Jackson's waived the time limits for the preliminary hearing. We'll schedule this matter for status.
Thank you
So
very
when you
much.
leave here, you'll sign your bond form, you'll get your next court date, make sure you're there.
How are we going today?
As far as I know, yes.
Okay, thank you so much. Next will be Ann Austin, appearing via Zoom.
This is 26 CM 1858, State of Wisconsin versus Anne Marie Austin. Appearances, please.
ADA Carl Lassers for the state.
Attorney Adam Welch from the Public Defender's Office appearing in court on behalf of Miss Austin. Miss Austin, is that you on the video?
Yes, it is, sir.
Did they give you a copy of the criminal complaint? It charges battery and disorderly conduct and another charge. Did you get that?
I just got it right now.
Okay. That complaint lists the Beacon at 615 East Washington as a mailing address. Is that still where you would receive mail?
Yes, and I also am a Dane County resident and also a Prairie du Chien resident because my brother lives in Prairie du Chien.
Okay, but you still want to use the Beacon for mail?
Yes, I do.
Okay. Your Honor, as alluded to, Ms. Austin has received the complaint. The address is accurate. We'll waive any further reading, stand mute to the charges. She is currently not eligible for public defender representation, but I will cover today's hearing.
All right, Ms. Austin, you've been charged with a crime, which means you have a right to be represented by an attorney. It sounds like you're not eligible for an attorney through the public defender's office. So your options then, if you wish to be represented by a lawyer, are to hire an attorney or to ask the court to appoint an attorney to you at county expense. You would have to take the documentation from the public defender's office indicating that you were not eligible for their services to the clerk of courts to apply for that. I've reviewed the complaint. It states probable cause, and I'll enter not guilty pleas on Ms. Austin's behalf. What's the state's position on bail or bond?
The state would ask for a signature bond with no contact with Stephen H.
No objection.
All right, then order a signature bond. Ms. Austin, while this case is pending, you are not to have any contact with Stephen H. And we'll be adjourned on this case.
Next is Anthony McCray. McCray? Good work. He's down in yellow vest.
Right here.
This is 26 CF 1731, State of Wisconsin versus Anthony McCray. Appearances, please.
ADA Carl Lazarus for the state.
Attorney Adam Welch appears on behalf of Mr. McCray. Your Honor, I just need one moment because I didn't have this complaint until right before court.
I don't think I did either, so I'll review it at the same time.
Where's that when you are, Your Honor?
Right.
I don't know where I was. Should I?
Know where you were.
Okay, so we've received a copy of the complaint. We will waive its reading. The address listed on the complaint, you still get. The address listed on the complaint is currently accurate. Mr. McCray has not yet been evaluated for a public defender.
Right. Mr. McCray, you've been charged with a crime, so you have a right to be represented by an attorney. It sounds like maybe the public defender wasn't able to evaluate your eligibility for their services before your court appearance right now. But the bailiff just handed you some information about applying for an attorney through the public defender's office. If you don't qualify for their services, your options are to hire an attorney to represent you or to ask the court to appoint an attorney to represent you at county expense. I will say I've reviewed this complaint, find that it states probable cause. What's the state's position on bail or bond?
Yes, the state is asking for cash bond in the amount of $10,000 and conditions not to operate a motor vehicle, not to possess or consume any alcohol, and also for referral to pretrial services for alcohol monitoring. The reason for the requests initially have to do with the allegation of the fleeing and eluding. indicating an unlikely, indicating that's unlikely, Mr. McRae will voluntarily return to court without sufficient cash bond. As alleged, this was a somewhat extreme flee eluding, at least as compared to other cases. Also, at the same time, Mr. McRae was on bond in a number of cases, 25 CF 1579, 25 CF 434, 24 CF 1049, I believe. I'm sorry, 24 CF 1389, and then 24 CF 1049. And then there are at least others that I see as well, including 24 CM 76, 24 CF 58, 24 CF 69. And I think those are all the ones I'm aware of. So essentially 4 from 2024, or I'm sorry, 5, and then 2 from 2025, and then this one in 2026. And it's possible I made a mistake in reciting the numbers just now, given the number of cases pending. Additionally, it's my understanding that there have been returns on warrant. My notes do not reflect what the failures to appear were, so I want to be careful alleging that there were failures to appear. I'd have to look at CCAP to give the court the exact information, but it's my understanding that there has been a history of bench warrant and bail violations. That might explain why some of these cases, including the 2024 ones, have grown somewhat older. And if I may just have one moment just to get the court that information. I apologize. I do not have the information about any failures to appear without going in all the cases. I'll try and find that information if they exist at all, but I know the court would like to move on.
All right. On behalf of Mr. McRae.
Thank you, Your Honor. From what I can tell based on public documents or CCAP documents, it looks like there's at least one case where it was filed with an arrest warrant. And then that was served very quickly, but that wouldn't constitute a failure to appear in my book because he was never given an opportunity to appear. The only other thing I'm seeing is 1 or 2 times in one of the 2024 cases where there was some sort of pretrial services alleged violation that resulted in a warrant being issued by the court and then him promptly, dealing with those, but those weren't failures to appear. Those were alleged pretrial services violations. I can't access the details of that, so I don't know what they were for. But again, that's not a failure to appear. So I don't think we have, from what I can see, any history of failure to appear. He does have an attorney through the public defender's office on his pending cases that he is working with to try to get those resolved. He's lived in this area for over 10 years. He hasn't been officially evaluated on this case, but given the appointment on the other cases, I believe he's indigent. He did recently get a job doing maintenance work, but that doesn't pay a lot of money. And I don't know if he'll still have that job after this arrest or not. But he doesn't have the resources to post anything like what the state is asking for. I understand based on the nature of the charges and the open cases that some amount of cash we may be in that realm, but I would ask the court to consider something more along the lines of $500 rather than what the state's requesting.
Does Mr. McCray have an attorney from the Public Defender's Office? I'm just looking on C Kevin, looks like there's a motion in order to withdraw.
Let
That
me
was
take a look.
last week.
Oh, I didn't see that. Yes, so it looks like he was appointed Kathy Chung. She moved to withdraw. That was granted just last week. And he is still eligible though on those cases, so he will be getting a new attorney appointed on those cases. Is that correct?
Yeah.
Yeah, okay.
In your honor, if I may just add, I believe there was one failure to appear, but that would be back. That would be over 2 years ago on January 5th of 2024 in 23 CF 1677. That's the information I have.
All right, thank you. Well, Mr. McCray is charged here with attempting to flee or elude an officer. It as well as three counts of felony bail jumping. He's got open cases where he's charged with similar sorts of offenses. Sounds like Mr. McCray has generally made his court appearances as required, but at this point, he's facing significant penalties amongst all of the cases. And I think cash bail is appropriate under these circumstances. I think there's some reason to doubt the likelihood that he's going to continue to make his court appearances, given what's alleged here, as well as the penalties that he's facing at this point. And, given what's alleged in the criminal complaint. I'm going to set cash bail in the amount of $5,000. As a condition of bond, I'll order that Mr. McCray is not to operate any motor vehicle. I think that's appropriate, given what's contained in the complaint and as well as what's charged in the other cases, that he not possess or consume any alcohol. I'm not sure about, I don't think pretrial services has the openings essentially to accept him. So I'm not going to include the pretrial services condition.
Right.
I assume that Mr. McCray would like the preliminary hearing scheduled in a timely manner.
That sounds good. Thank you.
All right, schedule the matter for a timely preliminary hearing.
Next is Ben Washington, appearing via Zoom.
All right, this is 26 CF 1718, State of Wisconsin versus Ben Washington. Appearances, please.
The state appears by Timothy Vierhoff.
Attorney Adam Welch appears on behalf of Mr. Washington. He appears by Zoom video from elsewhere in the jail. He is being required to crouch down and appear through a food slot in a metal door. We have received a copy of the criminal complaint against Mr. Washington. We will waive its reading. The address on the complaint is accurate. He does currently qualify for a public defender.
All right, thank you. I've reviewed this complaint. It contains probable cause. What's the state's position on bail or bond?
Commissioner, the state is asking the court to order cash bail in the amount of $1 million. I note that in this matter, Mr. Washington is alleged to have essentially gone and obtained a gun that he owned, gone over to a neighboring apartment building with a teenage girl who he knows to confront the deceased. fired multiple shots, killing him. So this is it's an intentional homicide where there was a series of actions. This is not spur of the moment. It took time to get the gun and go next door and confront him. It's a pretty strong case for the state, I would suggest, in that we do have at least statements that Mr. Washington made to his significant other, essentially saying that he did shoot the deceased, and to the child witness who was present for the shooting as referenced in the complaint. I'd ask that as conditions of bail, the court order Mr. Washington to have no contact with family members of the deceased, Travion F., and that he have no contact with the child witness in the complaint. The initials for the court are JJF with a date of birth of 5/17 of 2012, and that he not go armed. I'm happy to answer any other questions.
All right, thank you. On behalf of Mr. Washington?
Thank you, Your Honor. First of all, I just want to note that although the charge here is serious, Mr. Washington is presumed innocent, and just like everyone else, he should have the opportunity to get counsel, to fully investigate the facts of this case, and then to be able to present any defenses or other mitigating circumstances that may be appropriate. We are at the very early stages of these proceedings, and he is presumed innocent. I also want to note, and I guess sort of just remind everyone of what we already know, that the U.S. Constitution prohibits excessive bail. And although that's not defined, and it's certainly not defined as, you know, what's in anybody's bank account at any given time, excessive bail has some meaning. And I don't think the founders of the Constitution would have considered, you know, $1 million bail for a person who is legally indigent to be, you know, not excessive. It's excessive. This is a case where high cash bail is probably appropriate and called for, but high cash bail can mean a lot of different things. And the court needs to look at Mr. Washington's financial situation and other factors to determine what amount of cash bail is actually reasonable here. The public safety assessment was done for Mr. Washington, which is an evidence-based tool. Every single category on this would support his release. He is charged with a violent offense, but he has no prior criminal record, no misdemeanors, no felonies, never been arrested before as far as I am aware. He's never failed to comply with any court orders as far as I'm aware. He is 26 years old, I believe, and he's resided in Madison in this community for at least 14 years. He has he had a full-time job that he worked for the past 14 years. So he's very stable in the community. He resided with his partner and their 2 young children. So he was supporting a family. He is someone who is very stable in the community, who worked a job, rented an apartment, took care of his kids. There is no reason to believe that he would flee. There's no reason to believe he would fail to abide by any court orders. The allegations here are that after this encounter, Mr. Washington handled himself in an extremely responsible way. He's alleged to have locked up the firearm. He's alleged to have then contacted the police, calmly presented himself and cooperated with what he was told to do. That does not sound like somebody who is likely to fail to appear in court. That does not sound like somebody who's likely to flee the jurisdiction or disregard court orders. I would ask the court to consider what it believes to be a reasonable bail for a person who works a, you know, middle-class job, who rents an apartment, does not own, does not have family resources to draw on, and order a cash bail that the court believes is reasonable.
Thank you. Well, Mr. Washington is charged with the most serious of charges. It carries life imprisonment. I think that in and of itself provides some incentive not to appear in court, but even under under that analysis, cash bail is appropriate, but even under an Act 3 analysis, this is obviously an Act 3 offense. It's an intentional homicide. The need to protect the public under these circumstances is obvious. I think the state's request is reasonable and that I'll grant it. Order cash bail in the amount of $1 million. Order that Mr. Washington not have any contact with any family member of Travion F. Not have any contact with JF, whose date of birth is 5/17/2012, and not go armed with any dangerous weapon. I assume that Mr. Washington would like the matter scheduled for a timely preliminary hearing, Counsel?
Yes, please.
All right, that's how we'll schedule it. We'll be adjourned on this case.
Thank you.
Thank you. Next is Aaron Prince.
Wait, Brad, Eric, Brad. Wait, thank you. All right, fine. Your paperwork, please stay on the audience.
This is 26 CF 1726, State of Wisconsin versus Aaron Prince. Appearances, please. I'm sorry, there's another case here. It is actually a couple of other cases. I'll call all of them. 25 CF 1523, 25 CT 617, 25 CT 751.
ADA Carl Lazarus for the state.
Attorney Adam Welch appears with Mr. Prince. So if I'm understanding correctly, we have an initial appearance on one out of these cases. Is that the court's understanding? Okay. We have received a copy of that complaint. We will waive its reading. The address listed on the new complaint is accurate, and Mr. Prince does qualify for public defender representation. And if I could just have one moment to chat with Mr. Prince, I'd appreciate that.
And I had. They didn't take one of the cases, but I went.
Okay. Yeah, I saw that. Okay. All right. Thank you, Your Honor. We're ready to proceed.
All right, with respect to the complaint in 26 CF 1726, I reviewed it. It contains probable cause. The others are set for bail bond hearing. What's the state's position on bail or bond?
Yes, Your Honor. In the new case, 26 CF 1726, the state is asking for $1,000 cash bond with a condition of no controlled substances or drug paraphernalia without a valid prescription. The reason for those requests are, it's my understanding, the defendant has been in bench warrant status in a previous case that's pending since March. And that went up until the time of this arrest. For those reasons, we're making these requests. And then in terms of the other cases that are here on a bail bond hearing, we would just ask Your Honor to impose the same bond and same non-monetary conditions.
So $1,000 cash bail in each of these cases?
No, I'm sorry, the same previously imposed cash bond and non-monetary conditions.
Okay. On behalf of Mr. Prince.
Your Honor, we don't object to the state's request to reinstate the previous bonds. In the new case, we would object to the $1,000 cash that the state's requesting. The history here of the failure to appear is just a little strange. I spent some time poking around on CCAP on that because there was a weird overlap where he failed to appear in one case, but then appeared on another case. But then the warrant on the first case apparently wasn't handled or quashed at that point and remained outstanding. So I thought that was very strange and unusual. But then what I also saw is in the felony case, it appears that a notice was mailed to him. That notice was then returned as undeliverable and he failed to appear, but it appears that he did not get that notice. Now, I do think that given the amount of time here, one could certainly say that Mr. Prince maybe should have tried to reach out or done something. But I think there was a lot of confusion that happened. And, I think sometimes these things just happen. He doesn't have the resources to post cash bail right now. He's out of work. He usually works sort of doing contracting type work, but has been out of work for a while. He's on food stamps right now, but really doesn't have any other source of support. So I'd ask the court to consider something less than what the state's requesting.
I'd just like to confirm the address again. You said that the notice was returned in that case. It looks like the notice was mailed to 129 Robin Ridge. That's the address in the new complaint.
Yeah,
Keep using that?
any reason why that would be returned? I don't know. Whose name is somebody else's name on the box there?
Yeah, it's spot on.
What's his last name?
Picala,
Okay, maybe that could be the issue. What's his full name?
Ron, Beaugete,
And the last name?
Picala, Pakkala.
P-A-K-K-A-L. Okay, I think maybe the issue is that his father-in-law's name is the one that's on the mailbox, so maybe we could edit this to say care of Vaughn Pakkala, it's Vaughn, last name P as in Paul, A-K-K-A-L-A. That would probably be the issue. Thank you.
Counsel, can you tell me the warrant was issued March 20th of 26? Can you tell me which case it was in which Mr. Prince made an appearance after that?
Yes. I just need 1 second, Your Honor.
Sure.
All right, so in 25, let me just double check something here. Right, okay, so in 25 CF 1523, that's the one where the warrant or the notice was sent. It was returned undeliverable and he failed to appear on March 20th. Then in 25 CT 751, he appeared on 3/30/26. So 10 days after the missed appearance, he appeared out of custody voluntarily. And then nothing was addressed at that point.
I had a warrant at that point.
And yeah,
Another case.
right, and they didn't
They
address
took it
that,
out,
yeah. So that's what I was referring to, is that I thought it was very unusual that he appeared when apparently a warrant was already outstanding, and normally that would result in getting the warrant quashed or that he'd be arrested.
I thought I would.
It is, I suppose, but it does look like then that he received a signature bond on March 30th and then didn't appear the next day on April 22nd.
That is true.
I think, given all of the circumstances, I think there's good reason to believe that Mr. Prince is not likely to appear in court as ordered. Given the history of non-appearance, some amount of cash bail is appropriate here. What I'll do is order $200 on each of these cases. That's a total of $800.
800 total.
Respect to the case 1726, actually, before I move on, with respect to the previous conditions will remain the same in the older cases. In the new case, I'll order that Mr. Prince not consume any or possess any controlled substances without a valid prescription, and that he not possess any drug paraphernalia. With respect to the time limits for the preliminary hearing on that 1726 case.
Can we have it set within 20 days, please?
Yes.
Thank you.
All right, Roger.
Right.
Next is Vincent Corner, appearing to be assumed.
Right, this is 26 CM 1859, State of Wisconsin versus Vincent Corner. Appearances, please.
ADA Carl Lazarus for the state.
Attorney Adam Welch appears on behalf of Mr. Corn. Sir, are you Vincent Corn? Okay, he's nodding his head. Mr. Corner is appearing by Zoom video from elsewhere in the jail. He is appearing from behind a door. He does appear to be able to hear us. We have received copies, or a copy of the complaint. We'll waive its reading and stand mute. The address on the complaint is accurate, and he does qualify for a public defender.
Thank you. I have reviewed this complaint. It contains probable cause. What's the state's position on bail or bond?
Yes, Your Honor. The state would ask for a signature bond with a ban from J.C. Penney.
No objection.
Locations. I think that's everything. Yes.
No objection.
All right, I'll order a signature bond in this case. I'm not sure I said that we were going to enter the not guilty pleas, but we'll get the not guilty pleas entered via signature bond, a ban from J.C. Penney. Mr. Corner, you'll get your next court dates when you leave here. Make sure that you return to court. All right. Return.
Next is Wesley Williams. Wesley Williams. You stay on your legs.
This is 26 BF 1635, State of Wisconsin versus Wesley Williams. Appearances, please.
ADA Carl Lazarus for the state.
Attorney Adam Welch from the Public Defender's Office appearing with Mr. Williams. We've received a copy of the criminal complaint. Is that address covered? 2301. The address on the complaint is accurate, and he has not been evaluated for public defender at this time.
Mr. Williams, you've been charged with a number of crimes here. You have a right to be represented by an attorney. Sounds like maybe the public defender wasn't able to evaluate your eligibility for their services before this court date. And so I think that bailiff provided you a form there which contains instructions about how to apply for the public defender's office. If you don't qualify for a lawyer through the public defender's office and you want to be represented by an attorney, your options are to hire an attorney to represent you or to ask the court to appoint an attorney too. I've reviewed this complaint. It contains probable cause. What's the state's position on bail or bond?
Yes.
Is there I don't see anybody connected to the hearing, although I have a note saying that there's a victim who might want to be heard on this case. If there's somebody connected who I can't see who wants to be heard on this case, go ahead and make any statement you wish to make. Otherwise, Attorney Lazarus, go ahead.
Yes, Your Honor. The state would ask for a signature bond, conditions of no contact with Danita H., a ban from the 800 block of St. Albert the Great Drive in Sunbury, and a ban from any place Danita H. occupies, and also no alcohol.
Can you spell the name, please?
Yes, I believe it's Denita.
Danita H?
Correct.
Okay. Any objections?
No objection.
All right, I'll order a signature bond with those conditions. Mr. Williams, when you leave here, you'll sign your bond form and you'll get your next court dates. Make sure that you come back to court on the next date. This is a felony, so you'll have a right to have a preliminary hearing. When should we schedule that, counsel? Thanks.
Yeah. Right.
Okay, we'll waive the time limits so he has time to figure out his representation.
Okay. We'll waive the time limits for, sorry, I'll find that Mr. Williams has waived the time limits for the preliminary hearing. We'll schedule the matter for a status. Mr.
Right.
Williams, when you leave here, you'll get that date. Make sure you come back to court, whether or not you have an attorney on that date. All right, we're adjourned.
Next is Dylan Randall, appearing via Zoom.
All right, this is 26 CM 1851, State of Wisconsin versus Dylan Randall. Appearances, please.
ADA Carl Lazarus for the state.
Attorney Adam Welch appears on behalf of Dylan Randall. I'm appearing in the courtroom. Mr. Randall, is that you? Are you Dylan Randall?
Yes.
Okay. Dylan Randall is appearing by Zoom video from elsewhere in the jail. He's appearing from behind a door. We will waive reading of, we've received the complaint, we'll waive reading of it and stand mute. The address on the complaint is accurate and he has not been evaluated for a public defender yet on this case.
All right, Mr. Randall, you've been charged with a series of crimes here. You have a right to be represented by an attorney. Apparently, the public defender's office wasn't able to evaluate you before right now. And so if you want to be represented by an attorney, you'll have to contact their office and complete the evaluation process. I reviewed the complaint. It contains probable cause. What's the state's position on bail bond?
Yes, Your Honor. The state would ask for a $1,000 cash bond, no contact with Nicholas L. or Julia W. in a band from the UW campus. The reason for these requests are it's the fourth pending case. The cash bond seems necessary, although this is not an Act 3 offense, because this is the fourth pending case, because there appear to be significant concerns that the defendant will not appear in court based upon what's alleged is his inability to comply with his bond conditions. In the three other cases, which I think all occurred or alleged to have occurred within the last couple of weeks, if I'm not mistaken. And so it appears there's a concern that Mr. Randall will not appear in court based upon his inability to comply with the basic bond conditions, especially in such quick succession. The state has no further argument.
On behalf of Mr. Randall?
Thank you, Your Honor. I would note that from what I can tell, Mr. Randall has no history of prior convictions. Though he does have open cases, he has not failed to appear in those cases. This is not an Act 3 eligible offense. I would request a signature bond on his behalf.
All right. The facts alleged in this complaint seem at least similar to at least the facts that are contained in 26 CM 1784. In that case, which was filed apparently 2 weeks ago, Mr. Randall received a signature bond. It doesn't appear that he's had any opportunity to either attend or fail to attend a court appearance. It's not an Act 3 offense. I think under the circumstances, a signature bond is appropriate in this case. That's what I'll order. As a condition of your bond, Mr. Randall, I'm going to order that you have no contact with Nicholas L., Julia W., and that you not be in the area depicted on the UW campus band map. You'll get your next court date before you leave. Make sure you attend your future court appearances. We're adjourned on that case.
Next is Chad Giroux.
Chad, good paperwork, sir. Let you stay on the lines. There you go.
This is 26 CF 1722, State of Wisconsin versus Chad, is it Giroux?
Yes.
Appearances, please.
ADA Carl Lazarus for the state.
Attorney Adam Welch appears with Mr. Giroux. We've received a copy of the complaint. We will waive its reading. The address on the complaint, well, hold on a second.
But is that still where you're presiding? Yeah, I think
Okay, the address on the complaint is accurate. And he does qualify for public defender representation on this case.
thank you. I have reviewed this complaint. It contains probable cause. What's the state's position on bail or bond?
Yes, Your Honor. The state is asking for $10,000 cash bond, condition of no contact with an individual with the initials SGV, and a ban from the 4500 block of Turquoise Lane, and no dangerous weapons. The reason for these requests are that I believe Mr. Giroux has 2 open felonies and 4 open misdemeanors in other counties. In Adams County case 25 CF 140, Mr. Giroux is charged with violent offenses, including strangulation, suffocation, and battery. I believe against the same victim in this case. In that case, the defendant posted $500 cash. And then there was a failure to appear on April 29th of this year. There's also a failure to appear in Sauk County case 25 CF 809 on March 27th of this year. This offense, or this case also alleges an Act 3 offense. The Act 3 offenses as alleged here, and also the one in Adams County that's still pending, combined with the recent failures to appear. And I believe Mr. Giroux had active warrants when this new offense occurred. All suggests under an Act 3 and a failure to appear analysis that high cash bond is necessary to protect the public and ensure Mr. Giroux's future appearance in court.
Thank you, Your Honor. So Mr. Giroux is a lifelong resident of the area. He does live at the address on the complaint, up in Friendship. He is employed. He does remodeling work, but he does not make enough money to, or he makes little enough money that he is indigent. He qualifies for public defender representation. He obviously is going to have to deal with the cases in the other counties, and they'll handle their bail separately. For this case, I don't believe a bail in the amount that the state is requesting is in any way necessary. I think we're probably in a situation where cash bail is on the table, but I think cash bail in the amount of $500 would be sufficient to assure Mr. Giroux's appearance in court, while also being within his means.
All right, thank you. It looks like Mr. Giroux posted $500 cash bail in this Adams County case and then failed to appear. There's a warrant outstanding for him in Adams County as well as in Sauk County. Either under failure to appear or Act 3 analysis, this is a case where cash bail is warranted. I'm not sure that it's warranted in the amount of $10,000 cash. But I think some significant cash is appropriate. I'm going to order it in the amount of $7,500. As a condition of bond, I'll order that Mr. Giroux not have any contact with SGB, that he not be at the 4500 block of Turquoise Lane, and that he not possess any dangerous weapons. I assume that Mr. Giroux would like his preliminary hearing scheduled in a timely manner.
Yes, please.
That's how we'll schedule it. Mr. Drew, when you leave here, you get your, the date for your preliminary hearing.
Next is Casey Joswiak, appearing via Zoom.
Okay with you?
Oriented at some point.
Somebody.
Yeah, 'cause there was a guy in here, he says,
So. As soon as.
All right, I'm gonna call this case. It's 26 CM 1866, State of Wisconsin versus Casey Joswiak. Appearances, please.
ADA Carl Lazarus for the state.
Attorney Adam Welch from the Public Defender's Office appears in the courtroom. Are you Casey Joswiak on the video?
yes.
Okay. they have an address for you on Valley View Court. Is that still accurate?
That's correct.
All right, Your Honor, Mr. Joswiak appears by Zoom video. He has received a copy of the complaint. We will waive its reading. We'll stand mute to the charges. The address is correct. He does qualify for a public defender.
All right, I've reviewed this complaint. It contains probable cause. What's the state's position on bail or bond?
Yes, the state would ask for $200 cash bond with a condition of no acts or threats toward Chad J and no alcohol. The reason for the cash bond request is because this is the third open case, and there are indications that Mr. Joswiak cannot comply with bond conditions, including the condition to come to court when ordered to do so. I'm not aware of any failures to appear, just in my notes. So I don't have any failures to appear to inform the court of. And I think that's everything the state has to argue.
All right.
Sorry, I think I may have misheard. I only see that there's one open case for Mr. Joswiak.
Okay, and would that have been, maybe the case you're looking at is 26 CF? No, I'm sorry, that's a different case.
The complaint says 25 CM 1951.
I do see that that one's open. There was a third case that is pending. It was awaiting initial appearance. I missed it when I was reviewing cases with this afternoon. It looks like it's set for an out of custody. Set for an out of custody initial appearance on August 24th at 8:30. I haven't reviewed it. I don't know if that has the same victim in it, if that's a case that we could address today, or if that has to wait until out of custody some other day.
I will check. There is no victim in that case. There's an allegation that Mr. Joswiak consumed alcohol in violation of his bond in Dane County case 25 CM 1951.
Copies of the complaint, maybe that is something that we can take care of today instead of having another separate court date.
Sort of thing.
We decided to take it up, and there's one copy for Attorney Gulch and another copy for the defendant.
That's fine. If the court want to address this one as well?
Sure, why don't we do that? Can you tell me the case number one more time?
26 PM 1699.
All right, in the event that it's necessary for me to officially call it, this is 26 CM 1699, State of Wisconsin versus Casey Joswiak. The appearances are the same. I've reviewed this complaint. It states probable cause. I'll enter not guilty plea on Mr. Joswiak's behalf. Does the state want to make a bail recommendation on this?
In that case, the state would just ask for because there's no victim in that case, the state would ask for a signature bond with a condition of no alcohol. And the state would just note that pending case, I believe, is 25 CM 1951. The court may have said that already. And I think Mr. Joswiak's in DPU, if I'm not mistaken, to the extent that information is relevant, but the state has no further argument.
All right. Any argument on behalf of Mr. Joswiak?
Yes, Your Honor. Mr. Joswiak has resided in this community his whole life. It looks like he was in deferred prosecution on another case. I'm not aware of any other record. It looks like the state agrees that there's no history of failures to appear. These are not Act 3 eligible offenses. And the allegations here basically appear to consist of allegations that Mr. Joswiak is having trouble controlling his drinking, which may suggest, if that's true, that he would be appropriate for some form of treatment or counseling or something like that. But I don't think it suggests that a cash bail is necessary to assure his appearance in court, given that there's no history of failures to appear.
All right, thank you. I just took a look at 25 CM 1951. Looking for some information about Mr. Joswiak's history of attending court. It looks like in that case, cash bail was initially set at $2,000 on August 26th. A few days later, that amount was posted by Chad J. And Mr. Joswiak was released from custody and attended court appearances as required. Eventually on November 6th, 25, that cash bail was amended to a signature bond and the cash was refunded. It looks like that Mr. Joswiak may have started participation in DPU shortly after that. But it does not appear that he has a history of not appearing in court, and given that information, I guess signature bond is appropriate here. On the newer case, 26 CM 1866, as a condition of your bond, Mr. Joswiak, I'm going to order that you not direct any acts or threats of violence toward Chad J, and that you not consume any alcohol or possess any alcohol. On the other case, 26 CM 1699, I'll order a signature bond in that case as well, and order that Mr. Joswiak will order that you not possess or consume any alcohol in that case either. When you sign your bond form, you're going to get dates for your next court appearances. Make sure you attend those as required. We're adjourned on these two cases.
Next is Lorenzo Washington.
Lorenzo what? In big words, please stay on the phones.
This is 26 CM 1855, State of Wisconsin versus Lorenzo Washington. Appearances, please.
ADA Carl Lassers for the state.
This is where you get mail. Yeah. Okay. So I've been talking on that. Okay. Attorney Adam Welch appears on behalf of Mr. Washington. He appears in person and in custody. We've received a copy of the complaint. We will waive its reading and stand mute to the charges. The address, currently Mr. Washington is getting his mail care of Safe Haven at 4006 Nakusa Trail, Madison, Wisconsin, 53714. And he does qualify for public defender.
Okay. I've reviewed this complaint. It contains probable cause. I'll enter not guilty pleas on Mr. Washington's behalf. What's the state's position on bail or bond?
The state would ask for a signature bond with a ban from Madison Metro buses. And that is everything.
On behalf of Mr. Washington?
Your Honor, no objection to the signature bond. I understand why the state asks for that condition. However, I don't think it's reasonable to, Mr. Washington is currently unhoused. He stays at the men's shelter. He goes to the Safe Haven during the day. He avails himself of the services that are available to people that are unhoused and trying to get back on their feet. These things are hard enough to navigate in the first place, and telling someone that they're not allowed to use the only public transportation that exists in Madison, I think just makes a hard situation worse. So I understand where they're coming from, but I do object to that request.
All right, thank you. I am going to order a signature bond in this case, and given what's contained in the criminal complaint, I think the state's request for a ban from the Madison Metro bus is appropriate. I am generally hesitant to order those because I agree with you, counsel, that it is hard enough to get around as it is, and a ban for Metro bus certainly makes it harder. But the allegations is that Mr. Washington was on the bus urinating and exposing himself to the other passengers, and I think that given those allegations, it's appropriate that he just remain off the bus while this case is pending. Mr. Washington, when you leave here, you'll sign your bond form, you get your next court dates, make sure you come back. Return.
All right, sir. Next is Marquise Ware, hearing via Zoom.
Yeah. Yeah.
All right, this is 26 CS 1728, State of Wisconsin versus Marcus Ware. Appearances, please.
ADA Carl Lazarus for the state.
Attorney Adam Welch from the Public Defender's Office appears in the courtroom. On the video, is that Marcus? Is that you? Marcus, where is that you? Can you hear us?
Yeah.
Marcus, where?
I can hear. What's up?
Is your name Marcus Ware?
Yes.
Okay.
Hey, don't be knocking.
Okay, we've received a copy of the new complaint against Mr. Ware. We'll waive its reading and send mute to the misdemeanor charge. I believe the address is correct for mail, and he has not been evaluated for a public defender on this case.
All right. I've reviewed this complaint. It states probable cause. We'll get that we'll enter a not guilty plea on Mr. Ware's behalf to count 1. Mr. Ware, you've been charged with 2 crimes. You have a right to be represented by an attorney. Sounds like the public defender wasn't able to evaluate you before today's hearing. If you would like to be represented by an attorney, you should apply at the public defender's office for their services. If you don't qualify for their services, and you wish to be represented by an attorney, you can hire one on your own or ask the court to appoint an attorney to you. What's the state's position on bail upon?
Yes, Your Honor, and I apologize. Did the court call the other cases, the bond cases?
No, but thank you for reminding me. There's one other case I see here, which is 26 CF 1579. We'll call that one, and the appearances are the same. It looks like this is here on a bail bond hearing after Mr. Ware failed to appear at a preliminary hearing last week.
Understood. And then there's also, just for the court's information, there's 26 CF 1223, but there may not be any need for a bond hearing in that case. There may be no bond violation. Yes, the state would ask for I would just ask for a signature bond, actually, given that the new allegation is possession of drug paraphernalia. And then Mr. Ware did miss court, it appears, last Thursday, but presumably he's been attending court in his other cases because he doesn't have a warrant in those other cases that I'm aware of. And he was only not complying with or had only failed to attend court for, I guess, a couple of days. If it was last Thursday that he missed. I guess the offense date for the new case was perhaps Friday or Monday. I'm not certain, but it hasn't been that long. So we would just ask for a signature bond in the new case with the State Street ban, and then reimposition of the same bond with the same non-monetary conditions in the new case, in the other case.
On behalf of Mr. Ware.
No objection.
Right. Well, Mr. Ware, the parties are asking that I order a signature bond in each of these cases. I'm going to do that, sir, but in the 26 CF 1579 case, you were supposed to be at a preliminary hearing last
I'm
week. I
sorry.
was there.
I'm
I was
sorry.
there, but you weren't. I just want to tell you, Mr. Ware, if that happens again, that you missed court, it's unlikely that we're gonna come here and the parties are gonna be, the state rather is gonna be asking for the same thing.
So that mean I can get out today?
Yes, sir. When you sign your bond form,
Thank you.
hold on, listen to
not
the rest
leaving.
of what I'm saying, sir.
I'm listening. I'm not leaving.
Okay. When you leave here, you're gonna sign a bond form. You're gonna get the dates for your next court appearances. Make sure that you come back to court. As I said, if you fail to appear again, I imagine that we're gonna be having conversation about cash bail. All right. The next one, the Nuke case needs a preliminary hearing. Should we schedule it in a timely manner or schedule it beyond the time limits?
Let's waive time limits and then they can presumably get them on the same date.
So I have another question, should we have felons waived in that Mueller case too? I think they weren't waived initially, so I'm still in court.
They weren't waived. Okay, I retract my previous statement if that's all right. Can we just set both of them within 20 days?
We can, if
Okay.
there's some difference to you, counsel, the other case originally had $150 cash bail.
Yeah.
At the time, the time limits weren't waived.
Yeah, so it would be 20 days on both of them presumably still.
We'll schedule both of these cases for timely preliminary hearings.
Were there any conditions that were in the case?
State street banner was requested.
That's what I thought I heard, but
Is that what you asked for? I didn't write it down.
Yes, because I believe that condition exists also in 26 CF 1579.
All right, then I'll order that. I'll order that condition as well. We'll be
Thank
adjourned on
you.
this one.
Next
Thank you,
is
Judge.
Osman Habib, in work, Stanley LX.
This is 26 CM 1850, State of Wisconsin versus Osman Habib. Appearances, please.
ADA Carl Lazarus for the state.
Attorney Adam Welch appears with Mr. Habib. He appears in person and in custody. One moment. 3917.
Oh, yes, the part name's 161.
Okay, good. 161, okay. We received a copy of the complaint. We will waive its reading. The address on the complaint is correct, but it's missing the apartment number. That's going to be apartment 161. If we could please add that. And then we'll stand mute to the charge. He was evaluated, but is currently not eligible for a public defender.
Mr. Habib, you've been charged with a crime here. You have a right to be represented by an attorney. It sounds like you're not eligible for an attorney through the public defender's office. So if you'd like to be represented by an attorney, your options are to hire an attorney to represent you or to ask the court to appoint an attorney to represent you. If you're going to do that, you'll have to take the documentation from the public defender's office showing that you're not eligible for their services to the clerk of court when you apply. The bailiff handed you some information about that just now. All right, I've reviewed this complaint. It states probable cause. I will enter a not guilty plea on Mr. Habib's behalf. What's the state's position thereupon?
Yes, we'd ask for signature bond with the only condition, no acts or threats directed at SGN. N, yes.
Any objection to that?
No objection.
All right, I'll order a signature bond in this case, Mr. Habib. While this case is pending, I will order that you not direct any acts or threats of violence toward the person with the initials SGN. When you leave here, you'll sign your bond form. You'll also get the dates for your next court appearances. Make sure you attend those court appearances.
Okay.
All right, we're adjourned.
Right.
With him?
Good luck. Next is Boo Lou appearing via Zoom.
That one I got. Thanks. I'll call the two cases here, 26 CM 1860 and 26 CM 1861. Both are state of Wisconsin versus Vu Lu. Appearances, please.
ADA, Carl Lazarus for the state.
Attorney Adam Welch appears on behalf of Vu Lu. The video, is that Mr. Lu? Is that your name?
Are you talking to me, sir? Yeah.
I'm talking to
My
you.
name
Is that,
is Tino, tiny in Italian. I'm
I'm sorry?
Italian. My name is Tino, tiny in Italian. Life is a mystery.
Okay, so I don't think that's the person we're looking for.
I'm Tino Bilu, Vu Bilu. Vu Bilu, 245 South Park Street, 387-889652. Is my social security number?
Yes, on the base.
Okay. Okay,
Seminaries where I went?
Mr. Lu, were you provided with 2 criminal complaints?
Yeah, I have a disorderly, a criminal trespass, a disorderly conduct.
Okay,
Italian FBI, secrets work, and they blew my cover.
okay. Okay. Number 1, I only have 1 of these complaints.
Okay. I have the
I have
other,
the
I have a. count
Yep,
one,
Mr. Lu, just 1 second, Mr. Lu, we'll be right back with you, okay? I only have the disorderly conduct complaint.
I'll print the other one for you, that's 1861. I did have to mute the defendant, it seems he's having some trouble not fighting over us. I mean, he is in a holding cell that's just down the hallway, if you want to have this guy later.
I'll let you know if I need to.
Sure. It's for 2 cents.
I have now received both complaints. Mr. Lu already has both complaints. The address on the complaints is accurate. I will waive reading and stand mute to everything. I am going to ask for an evaluation of Mr. Lu's competence to proceed, but I would request that we handle the getting bail set first.
All right, I've reviewed both complaints, both state probable cause. What's the state's position on the bail or bond issue?
Yes, Your Honor, the state would ask for in 26 CM 1860, the state would ask for a signature bond, a ban from the Summit Credit Union at 307 East Wilson Street in Madison, and also no contact with CEJ and SNS. In the other case, 26 CM 1861, the state would again ask for a signature bond with the conditions of no contact with an individual named Fung L. That's PHUONG, and a ban from the 3300 block of Quincy Avenue in Madison. Thank you.
We have no objection to those requests.
Okay, I just want to make sure I got the initials correct on the 1860 case. CEJ and SMS.
I'll go CEJ and the other initials are SNS.
All right, I will order signature bonds on each of these cases. On the 1860 case, I'll order that Mr. Lu not be at the Summit Credit Union on Wilson Street. I'll also order that he not have any contact with CEJ or SNS. On the 1861 case, I'll also order a signature bond and order that Mr. Liu not have any contact with Flong L, and that he not be at 3300 on the 3300 block of Quincy Avenue in Madison. We'll order the competency evaluation, given what's alleged in the criminal complaint and the representations by counsel, as well as Mr. Liu's conduct here in this hearing. I think there's reason to doubt his competency. Order the evaluation, the proceedings will be suspended. Do we need additional contact information for him for the evaluation?
That says that we can get that off the record. This is our last meeting.
Then we'll be adjourned. Thanks.